So thanks for joining us, everyone. And I want to start with Barack Obama. And seeing as unfortunately he couldn't be here today, I'm sad as well. I'm going to have to quote from his book, The Audacity of Hope, because it's sets the scene nicely, I think, for some of the topics that we'll talk about as part of this session. But also, as an added bonus, it explains my somewhat indifference towards social media and the social media age that we live in. So the quote's this: "A rejection of absolutism in all its forms may sometimes slip into moral relativism or even nihilism, an erosion of values that hold society together. But for most of our history, it has encouraged the very process of information gathering, analysis, argument, and persuasion, which allows us to make better, if not perfect, choices, not only about the means to our ends, but also the ends themselves." And essentially what he's saying there is that if you want to make good decisions, you should take account of the views of others. Now, if you want to see the polar opposite of that, then by all means log into your Twitter, or X, if you want to call it that now, account, and witness people shouting at each other in 280 characters or less, and all the nuance and complexity of the human experience is completely lost. Which brings me on to today's topic, because these issues are increasingly spilling over into the workplace. And whilst it's tempting for the employer to simply close down the debate, and in extreme cases that may involve disciplining or dismissing the individual concerned, the authorities are now clear that that will be the wrong thing to do unless the employer's given proper thought to the context and consequence of the employee's actions. And what this talk tries to do is to provide guidance on how the employer walks the tightrope of managing conflicting beliefs in the workplace. So let's have a quick run through the structure of the talk. So we'll look firstly, very briefly, at when a belief will be protected, and look at some examples of what haven't amounted to protected beliefs in cases that have run through the employment tribunals. Secondly, we'll look at what constitutes a manifestation of a protected belief, because it's only if conduct is properly to be regarded as a manifestation of a protected belief that we're into the territory of being especially careful as to how that conduct is managed by the employer. Thirdly, we'll look at whether an employer can restrict the manifestation of that protected belief, and that involves considerations of proportionality, and that in most cases is going to be the key question. Is the employer's proposed response a proportionate response to the conduct which is causing concern? And finally, we'll spend hopefully at least half of our time as part of this session looking at a specific case study that Sophie and I have written, and identifying some of the questions to run through the issues and the legal risks which might arise. One health warning, because we've only got 30 minutes and half of that time is going to be spent looking at the case study, that necessarily our review of the law will be relatively high level. But if you've got any questions about the law or generally about this topic, come and find Sophie during the coffee break, and you can fire away. We might be hiding. I don't know. So let me hand over to Sophie, who is going to deal first of all with when a belief will be protected.
Thank you, Dan, and good morning, everyone. You can obviously find Dan in the break if you need some guidance on the law. That might be better. You might be better for it. So starting with when will a belief be protected? Now, there is a more obvious question, perhaps, before we look at this, and that is, well, what is the belief? We need to know what the belief is in order to analyse whether it is protected under the Equality Act or not. And only once we have that can we start looking at the law. So let's assume that we know what the belief is. We then need to look at whether it's protected or not. And our starting point is the relevant provisions of the Equality Act. Now, Section 4 states that religion or belief is one of the protected characteristics, and Section 10.2 then defines belief as any religious or philosophical belief, and a reference to belief includes a reference to a lack of belief. Now, you might be sitting there thinking, well, thank you, Sophie, for showing the provisions of the Equality Act, but what on earth does any religious or philosophical belief actually mean? And very helpfully, the Appeals Tribunal has answered that for me. For a philosophical belief to be protected under the Equality Act, it has to satisfy the 5 criteria set out in Granger and Nicholson. Whilst that case dealt with specifically philosophical belief and the belief of climate change, it can also extend to religious belief as well. Now, those 5 requirements are that the belief must be, firstly, genuinely held. Secondly, be a belief, not an opinion or viewpoint based on the present state of information available. Thirdly, be about a weighty and substantial aspect of human life and behaviour. Fourthly, have a certain level of cogency, seriousness, cohesion and importance. And lastly, be worthy of respect in a democratic society, not be incompatible with human dignity, and not conflict with the fundamental rights of others. So those are the 5 main criteria that the Appeals Tribunal set out in Granger. There were some other comments in respect of what a philosophical belief might constitute, such as the belief need not be shared by other individuals, nor does it need to be a fully fledged system of thought. And that's all very well having 5 criteria, but how have the tribunals actually implemented that in practice, and what beliefs or purported beliefs have they found to constitute a protected belief or not? Certainly over the years, they have applied this criteria to several beliefs, and we have set out a flavour of them for you. And I must confess, as Carol said earlier, you will need to have a magnifying glass, I think, to read these slides, so apologies in advance. But before we go to the examples, it's perhaps worth noting a couple of things. Firstly, tribunals have to be careful to not inquire into the validity of a belief, and they have to remain neutral as to a belief. So if it's upheld as a protected belief, that's obviously not necessarily a indication of how a tribunal views the belief, but rather it's their application of the criteria to the specific facts. And that leads me to the second word of caution, which is that tribunals must consider each case, as most cases, on its own facts, in light of the criteria and in light of each specific claimant it has in front of it. So it's certainly not the case that if a belief is protected in one instance, it's automatically going to be protected in another. For example, with ethical veganism, in one case, which you may be familiar with, it was found to be protected. However, a claimant's veganism in another case was found not to be protected. And so one should be careful to translate these cases into others. So looking first at beliefs found to be capable of protection, and I'm sure you'll be glad to hear that I will not be going through each and every one of these, but you will see, as a flavour, that tribunals have found protected beliefs to include spiritualism, ethical veganism, as I mentioned, gender-critical belief, and one of the more recent cases, anti-Zionist belief, was found to be a protected belief. Now, on the flip side, beliefs found not to be capable of protection. Again, a long list, and please do, I invite you to look at them in your own time if you're just dying to know more about it after this talk, as I hope you will be. But to take a few examples of what has found to not be protected beliefs, these include Nazism, vegetarianism, the fear of catching COVID-19, very, very topical, was not a protected belief. And supporting a football club, for those supporters out there, I'm afraid that is not a protected belief under the Equality Act, unless the Appeals Tribunal overturn that decision. So that's belief. That's what is a protected belief. Now, as Dan mentioned, the next question is the conduct we're concerned with a manifestation of that belief? And what do I mean by manifestation of belief? Well, putting it quite simply, it is that it's an act where there is a sufficiently close and direct nexus between the act and the underlying belief. So By way of example, this might include the wearing of a certain item, for example, a crucifix necklace or a cross necklace, which is as a result of the underlying belief. Or it might be a refusal to do duties because of their underlying belief does not allow them to conduct the certain duty they're being asked to do. Or it might just be the expression of their belief, whether that be externally or internally, which is linked to their specific belief. So that's manifestation of a belief. Now we come on to the million-dollar question, which I'm sure is what you actually want to know about, is whether an employer can restrict the manifestation of a protected belief, or to what extent can they? And this is really the important question, and it's not a simple answer. It's a question of proportionality. Managing manifestations of belief in the workplace for the employer requires them to strike balances between the individual's convention rights, the beliefs of others, and also the ethos of the organisation that they're a part of. And in doing so, they must be careful to not breach their duties under the Equality Act. Now, the two main risks when you are restricting or challenging someone's manifestation of belief is indirect discrimination or direct discrimination. And to avoid both of these claims, any interference must be proportionate. So proportionality is key, albeit they come into the question in different ways. As to direct discrimination, and you'll see on the board, there is quite a key distinction, and that is looking at the reason for the treatment or the reason for the interference. If the reason for the treatment or the interference is because of the belief or the manifestation of the belief, then that will constitute direct discrimination. However, if the interference or the challenge, the restriction, is because the individual has manifested their belief in some way to which objection could justifiably be taken, that's a bit of a mouthful, I know, then a proportionality test must be applied, and only if it's objectively justified, the treatment is objectively justified, will it not amount to direct discrimination. So that's where the proportionality element feeds into it. In respect of indirect discrimination, as with other claims, the focus on whether the employer's restrictions on the right to manifest the belief will be whether it's a proportionate means of achieving a legitimate aim. So, as I said with both, clearly the concept of proportionality is crucial, albeit in different ways. And with that, I'll pass you back over to Dan, who will look at the concept of proportionality further.
Thank you. So what do we actually mean by proportionality in this context? Because the difficulty with proportionality is that whilst it's easy to state the principle, it's harder to apply in practice, and that's a position which I think any of us who have run indirect discrimination claims will be familiar with. And there wasn't really any authoritative explanation of how proportionality should be approached in this area in the employment context until we got the decision of the Employment Appeal Tribunal in Higgs and Farmers School, which was handed down in June of last year. And that really should now be the first port of call for all employment lawyers when deciding issues of proportionality when looking at the management of the manifestation of a protected belief. And what that decision did was to give us two things. Firstly, a set of key principles to be applied universally. But secondly, an indicative list of relevant factors, so things that could be relevant to the proportionality exercise. And I'll look at the principles first. And the starting position is that freedom of speech and freedom of expression are foundational rights. And one consequence of that is that the manifestation of a belief isn't objectionable simply because somebody might be offended by the thing said or done. However, although foundational, they are qualified and they can be limited to the extent necessary for the protection of the rights and freedoms of others. Context is key. That's the bit that we probably could have worked out for ourselves before Higgs came along. But nonetheless, whether a limitation or restriction is objectively justified will always be context specific, including in the context of the employment itself. And then finally, it's necessary to ask the questions that come from a Supreme Court decision called Bank Mellat and Her Majesty's Treasury number 2. And those questions are these, and they're questions which will be familiar again to those of us who have run justification defences in the context of indirect discrimination claims, because it's a broadly similar exercise. So firstly, is the objective sufficiently important to justify the limitation of a protected right? Secondly, is the limitation rationally connected to that objective? Thirdly, could a less intrusive limitation have been used without undermining the achievement of the objective? And fourthly, the balancing exercise which we're used to in relation to indirect discrimination, in which one balances, in this context, the severity of the limitation on the rights of the individual concerned against the importance of the objective, and you consider whether the former outweighs the latter. We then come on to the indicative list of factors in the employment field. And whilst this is very helpful, I think you have to treat it with some degree of circumspection, because it is an indicative list. And whilst it's tempting as employment lawyers to go through these lists as sort of a checklist and to go through them one by one, they may take on more or less importance depending upon the facts of a particular case, and there may be other factors which are relevant which aren't listed here, depending on the case. But going through the factors which are identified in Higgs itself. So firstly, the content of the manifestation, essentially what was said or done which has caused concern. The tone used. So for example, was it matter of fact, or was it done in a manner that could be perceived as abusive? The extent of the manifestation. The worker's understanding of the likely audience, so who was the conduct directed towards? The extent and nature of the intrusion on the rights of others and any consequential impact on the employer's ability to run its business. So to give an example, our staff spending more time falling out with each other than actually working. Next, has the individual made clear that the views expressed are personal? Or are they holding themselves out as representing the views of the employer? And obviously with the reputational risk that that latter scenario entails. Whether there's a potential power imbalance, given the nature of the worker's positional role and that of those whose rights are intruded upon. If a senior manager is exploiting his or her authority in order to impress upon a more junior employee their views, then again that has the potential to take that conduct into a more serious category. Nature of the employer's business, that includes the employer's ethos. How do they want to present themselves to the outside world? That is a relevant factor. And whether the limitation imposed is the least intrusive measure open to the employer. So that's the framework. And now that we've set that out, let's put it into practice by looking at a case study. Now, don't worry, I'm not going to ask for audience participation unless you really want to. Feel free to put your hand up if you really do want to participate, but otherwise Sophie and I will discuss it between ourselves. But let's look at the scenario that we've written, and I'll simply read it out to begin with, just so we can look at the detail of it. So Mr. Thomas is employed by a local authority as a registrar for births, marriages and deaths. He is an atheist. His favourite book is Richard Dawkins' The God Delusion. He has a LinkedIn account which he set up personally, but which identifies him as a registrar for the local authority. He routinely posts business as usual information to his LinkedIn account, such as job vacancies and local authority initiatives. He's also prone to post the slogan, quote, "Belief in the flying spaghetti monster would end world conflict," on LinkedIn posts and message threads, which he perceives to be related to religious conflict. Just pause on that, we haven't made up the flying spaghetti monster. That is actually a feature of one of the chapters in The God Delusion, and the point of it is, that I'm not endorsing this point of view, is that you can make a penny god, and it's no less logically coherent to believe in that god than any other god. And that's the point of one of the chapters. So Mr. Thomas has begun offering copies of the Gospel of the Flying Spaghetti Monster to his work colleagues. Again, that exists. You can get it on Amazon if you're interested. A colleague has approached HR to raise a concern over Mr. Thomas's behaviour. They didn't want to raise a formal complaint and wanted to make it clear that they weren't themselves offended by Mr. Thomas's behaviour, but thought others might be. No other employee has complained. There is no evidence that Mr. Thomas has ever discussed his atheism with service users or the public generally. The local authority wants to know what can be done to stop Mr. Thomas writing posts about the Flying Spaghetti Monster on LinkedIn and from offering copies of the Gospel of the Flying Spaghetti Monster to his colleagues. So what we do now, or what we'll hopefully do now, is just set out the sorts of questions that we would ask ourselves if we're confronted with that particular scenario and being asked to provide that particular advice. And I think it's a healthy exercise just to go through them one by one and structure them in a similar way that we have. So let's start with the easy questions. These are the universal questions which have to be asked in all cases of this description. So firstly, what belief is in play? What belief does Mr. Thomas have in this case? Well, clearly it's atheism, we're told that. And one moves from that question to the next, which is, well, does that belief constitute a protected belief? Clearly it does, because an absence of belief, and the Equality Act says this explicitly, an absence of belief is to be treated in the same way as actually holding the opposite belief. And thirdly, is Mr. Thomas's conduct properly to be regarded as a manifestation of his protected belief? And whilst that's not quite as clear-cut, I think the answer to that is obviously yes. It's tempting, and this is where the advice in Higgs not to make assumptions potentially comes into play. It's tempting to think that there is something facetious about Mr. Thomas's belief in the Flying Spaghetti Monster, but actually it makes a point that is important to, he would say, his atheistic belief. And I think genuinely in this case, Mr. Thomas's conduct would properly be regarded as a manifestation of his protected belief. So things that I would be tasking the employer as the client with either doing or thinking about before providing the advice. Well, first of all, what policies are thinking. You need to dig those out, or at least the ones that could potentially be relevant, and to review them before being able to provide a proper proportionality assessment in view of the limitations that the employer is proposing. So there are many that could potentially be relevant on the facts of this case. There might be a diversity or inclusion at work policy which prescribes the extent to which employees can manifest their beliefs in the workplace. There might also be a social media policy which again sets out the extent to which employees can set out non-business related matters as part of their work-related social media accounts. There's then also a need to highlight the legal risks to the employer that arises from the management of Mr. Thomas in this case. We've set them out in bullet point form in the slide. They're all reasonably self-evident. The first, of course, is trust and confidence. If the employer approaches the management of Mr. Thomas in an oppressive or high-handed manner, that has the potential to impact upon trust and confidence implied into Mr. Thomas's contract of employment. Direct and indirect discrimination, essentially for the reasons that Sophie has already very capably dealt with. And finally, which is one which could easily be overlooked, but is important, I think, certainly on the facts of this case, is harassment. And that's not just by Mr. Thomas, based upon what he might perceive as a limitation of an expression of his personal beliefs, but also by his work colleagues. There may be colleagues who are offered a copy of the Gospel of the Flying Spaghetti Monster who are offended by that conduct and who they say creates an adverse environment which they say is related to their religion or belief. But also I'd be asking the employer in this case, well, what is the reason for the restriction? Does the employer regard the conduct as objectionable? And more fundamentally, why, in the context of this employer, in the context of what Mr. Thomas has done, why do they regard it as objectionable? And finally, before we come on to some of the proportionality factors that were identified in Higgs as they apply to this case, you need to know with some precision what it is the employer is actually proposing to do, because it's only by framing the limitation or the proposed limitation precisely that one can carry out a proper proportionality exercise. So in this case, do they want to preclude him from posting about non-work related matters as broad as that? Or is it specifically related to him posting about the Flying Spaghetti Monster because there's a concern that it's seen as facetious and insulting? Or is it about the slightly broader topic of atheism, or is it something else? And the way in which the limitation is defined has a direct bearing upon how you go about the proportionality assessment. And in relation to the book, do they want to prevent him from approaching colleagues from offering the book, discussing atheism, or something else entirely. And we then come on to assessing proportionality on the facts of this case. The first issue, of course, is consistency in treatment. Would the employer's proposed approach show consistency of treatment across the workforce? For example, would a ban on promoting the gospel of the flying spaghetti monster be consistent with the employer's management of other beliefs in the workplace? Because if there isn't consistency of approach, that is something which militates against a finding of proportionality. We've then got 7 numbered points on the slide. I think Sophie and I are going to bounce them between ourselves one by one. I think Sophie's going to deal with the first, so I will briefly pass back to her in order to deal with that.
Thanks, Dan. So the first one is the content and tone of Mr. Thomas's communications. So looking specifically at what he posted, I'm not expecting you to remember that, but it is on the slogan, "Belief in the flying spaghetti monster would end world conflict." And the other thing he's been doing is passing out the copies of the Gospel of the Flying Spaghetti Monster to work colleagues. So looking at those without any further context or content itself, his tone of expression does not appear to be particularly extreme, not least in comparison to other things that you might have seen on LinkedIn, though it is clearly sarcastic, and the content itself may be perceived to be derisory to those who have a religious belief or other belief.
So, second factor, who did Mr. Thomas understand was the intended audience for his communication? Well, in offering the book to specific employees, then plainly it's the people who he speaks to. Although I think it would be relevant to consider whether there's evidence of his targeting specific groups or whether his approach is indiscriminate. So, taking an example, if there's evidence that Mr. Thomas is specifically targeting people he perceives to hold a Christian belief, that has the potential, I think, to take his conduct into a more serious category. Now, regarding his LinkedIn posts, I think the difficulty for Mr. Thomas is he doesn't know who his audience is, because his comments can be viewed by anyone who chances upon them, and his comment will be therefore linked to his employer through his profile. So these are, I think, factors which are in favour of some degree of limitation of his expression, applying proportionality.
So thirdly, to what extent are the communications connected to his work, his employer, or the workplace? You may have gathered from what Dan has just commented on. In relation to LinkedIn, it is naturally, as most of us, if not all of us here know, is a professional networking platform, and it specifically identifies him as a registrar for the local authority, and on it he routinely posts business as usual posts. Likewise, the copies of the gospel he's been offering to his work colleagues. Now, we don't know where he's been offering that, whether it's at work, etc., and that might be something that you wish to explore further. Nevertheless, for the reasons stated, I don't think you could say it's unconnected to his employment or his work.
So next one, to what extent do Mr. Thomas's communications intrude on the rights of others? It being noted that there's no universal right not to be offended. I think there is a legitimate distinction to draw here between mere strangers on the internet and Mr. Thomas's work colleagues, because what is the meaning behind offering the book to his work colleagues? And it's important not to make assumptions, but I think it's a reasonable inference from the nature of the book that's being offered, that there's at least an implied suggestion that there, as in the other employees' beliefs, is nonsense, and this book will help them to come to that conclusion. Is that an infringement of their rights? I think probably it is. Certainly would be in the face of any complaint by those individuals.
So fifthly, can the communications properly be seen as an abuse of the authority conferred on Mr. Thomas through his employment? Well, this is fairly simple to answer on the facts here, in the sense that we know there's no evidence, albeit that might not mean that it's not happening, but there's no evidence that Mr. Thomas has ever discussed his atheism with service users or the public generally. And so on that basis, it's hard to see how the communications could be seen as an abuse of authority conferred onto him. Obviously, if that was different and he was reaching out and using his position to preach about the spaghetti monster to service users, that might lead to a different conclusion.
Next one, did the communications interfere with the proper operation of the employer's business? Probably a neutral factor on the facts of this example, because, again, there's no evidence at present, and there would need to be some evidence, that Mr. Thomas had spoken to, for example, service users, or that the local authority's operations had been affected in some way.
And lastly, whether there's a risk of reputational harm. Well, like with the last two answers, this is a real matter of evidence, and to a certain extent would depend on the local authority's approach to their work and how they expect their employees to behave in conducting it. In this case, there doesn't appear to be any allegation by the employees or colleagues that there is any reputational harm that has been caused or would be caused in this instance by what is being posted or his actions with his colleagues. And if it was to be alleged, I think there would need to be some real evidence in respect of this to demonstrate that there has been or would be a real risk of reputational harm.
And the final factor is whether there are any less intrusive measures open to the employer, and that's where defining precisely what it is the employer is proposing to do becomes important, because if the employer's preferred outcome is at the more severe end of the spectrum, so for example dismissal or some other disciplinary action, then of course the availability of less intrusive measures would become very relevant in that situation. So what's the answer? Well, should we take a straw poll? Go on. If you can bring yourselves to put your hands up in the air. Who thinks dismissal is proportionate? Anybody? What about disciplinary action short of dismissal? So, for example, a written warning. Who thinks that would be proportionate on the facts of this case? No. Anybody think that telling him to stop doing what he's doing is a proportionate response to the action? Most of us. Anybody think the employer should simply do nothing and let him carry on with what he has been doing? Interesting. Good. Well, that brings us to the end of our session. It's been an absolute pleasure and delight. So, sadly, no time for questions, but we're going to be hanging around during the coffee break.
Yeah, so I'm delighted to say it is the coffee break, and Dan and Sophie are not allowed to escape and are just chomping at the bit to answer any questions. We're going to resume at 11:30 with Daniel Tatton-Brown and Ben Gray talking to you about the hard questions with covert recordings. If I could ask you to be back in your seats by 11:30. If you're not back in your seats, you will hear Liz shouting at you, and we will be calling upon the flying spaghetti monster to rain down sauce upon you. So thank you, and we will see you for coffee.